Good afternoon, everyone. I'm Robert George. I am McCormick Professor of Jurisprudence here at Princeton and Director of the James Madison Program in American Ideals and Institutions. It's my very great pleasure to welcome you today to a very important annual event in the life of the Madison Program, and that's our annual Walter F. Murphy Lecture in American Constitutionalism. The lecture honors my great immediate predecessor as McCormick Professor of Jurisprudence, Walter F. Murphy. Professor Murphy, with whom I had the pleasure, or under whom I had the pleasure of teaching for about 15 years after I arrived at Princeton back in the Middle Ages. Professor Murphy was a graduate of the University of Notre Dame who did his PhD at the University of Chicago in the field of judicial behavior, studying all the factors that went into judging, the things that made judges tick, made judges do what they do. And then later, having conquered that mountain, he turned to the questions of constitutional interpretation and comparative constitutional law that occupied his very distinguished career for the rest of his life. For those of you who are not familiar with the Madison program, we are a program dedicated to exploring enduring questions, the perennial questions of American constitutional law and Western political thought. You can learn more about our program and its activities at our website, JMP, James Madison Program, jmp.princeton.edu, and you can follow us on X at, here's our Twitter handle, @Madison Program. On our website, you can sign up for our newsletter, which will tell you all about events like this one going into the future. And I hope that you will subscribe to our Madison's Notes podcast, led by our wonderful podcast queen, Laura Laurent. We're very honored today to have as our 2025 Walter F. Murphy Lecturer, Professor Garrett West. Professor West is Associate Professor of Law at Yale Law School. His scholarship focuses on the uses of private law theory in public law and on the problems of constitutional interpretation and doctrinal coherence through constitutional change. He earned his JD at Yale Law School, where he was articles and essays editor of the Yale Law Journal, and got his BA from the excellent Hillsdale College in Michigan. After graduating from law school, Professor West practiced appellate litigation in Washington, D.C., and he clerked for three great friends of the Madison program, three great jurists who have done wonderful things for our program. Judge Diarmuid O'Scannlain on the U.S. Court of Appeals for the Ninth Circuit, Judge Thomas Griffith on the U.S. Court of Appeals for the District of Columbia Circuit, and Princeton alumnus Justice Samuel Alito on the Supreme Court. Today's lecture is supported, we're grateful, by the Boughton Law Lecture Fund, and its title is Constitutional Private Law. Please join me in welcoming Professor Garrett West.
Well, thank you. I am delighted and honored to be here. Frankly, it's quite a surprise. The last time I was here at Princeton, I was a senior in high school visiting the college, and I really wanted to attend. But the people at admissions have very high standards and decided I ought to go somewhere else. So at the end of the lecture, you all can decide who has the better judgment, the admissions department or Professor George. It's also really something to give a lecture in honor of Walter Murphy. Professor George mentioned many of his contributions, but one thing that was left off was that he was the thesis advisor to my former boss, Justice Alito. And I thought at the time when I was looking into Walter Murphy's career that this solved a great mystery, because when Justice Alito went to Yale Law School and took constitutional law, as he tells the story, he took it from Charles Reich. And over the course of the entire semester, he wrote down every case that they talked about in the course. And by the end of the course, he'd written down one case. And about halfway through the semester, at some point, he came back, and written on the board were the words, "I've gone to California and class is canceled." So the question was always, where did Justice Alito learn constitutional law? And I guess the answer is here with Professor Murphy. So my topic today is constitutional private law, and the term is supposed to be provocative because the standard effort to distinguish private law and public law would classify constitutional law as public law. So on one theory, indeed a very old theory that goes back to Justinian at least, private law is about the duties that private persons owe to one another. It includes the rules of property and tort and contract. And those are the courses that you take in your first year of law school, unless you go to Yale, where you don't have to take property, but for now you do have to take torts and contracts at least. On the other hand, public law is about the operation of the government and its relationship to citizens. So all of the familiar topics of constitutional law tend to fall within public law. What enumerated powers does Congress have? When does Congress have to declare war? Can the president remove officials from the executive branch or refuse to spend appropriated money? What kind of laws do the Free Speech Clause or the Second Amendment preclude? And so on. All of those, both that concern the structure of the government and also those that concern individual rights, tend to be classified as public law. But my thesis today is that much of constitutional law is much more like private law. It's much more like the law of torts and contract and property. I'll argue that this pocket of constitutional private law should be distinguished from constitutional public law. I'll argue that this distinction matters to how we would think about constitutional law more generally, and shows that constitutional law has multitudes of aims that the structure of the different legal rules reveals. And then I'll suggest that the multiplicity of aims and the different structures of constitutional law explains part of why it makes sense to study constitutional law in law schools and also in political science departments and also in all the other very many departments in the universities. So first, let me say what I mean by constitutional private law, and then I'll give a brief overview of what I'm going to talk about for the rest of the talk. So when I say constitutional private law, I'm referring to a body of law that operates as both a kind of private law and as a kind of constitutional law. So why is it private law? Well, it's private law in the following sense. It imposes relational duties that are thought to originate in the Constitution on government officials. And it requires that if these duties are breached, the official has to pay money damages to the victim for the breach of that duty. So let me break that down a little further. First, the constitutional private law duties are relational. They're relational because the officials thought to owe a duty to a specific person, not just a general obligation to the public at large. So a police officer might have a general obligation to protect and serve, but he also might have specific obligations to particular persons that he meets and that he interacts with to use only reasonable force in making arrests and so on. Second, the constitutional private law duties are imposed on government officials. I say officials because the duties apply to particular persons, like the police officer, and not generally to the abstract entity that we would refer to as the government or the state. It's about the individuals themselves. And third, although they're imposed on officials in particular rather than the government in the abstract, they're still thought to be imposed by the Constitution, by the Fourth Amendment or the First Amendment or the Eighth Amendment or the 14th Amendment's Due Process Clause or Equal Protection Clause. And finally, this is also, the constitutional private law duties require redress of a very particular kind, and it's usually the payment of damages when that duty is breached. So here's an example that draws out all of those points. If a police officer uses force, excessive force when making an arrest, the victim could sue that officer for an unreasonable seizure under the Fourth Amendment. The lawsuit would be brought against that official in what's called her personal capacity, meaning that the judgment for damages would require the official herself to pay the damages. And we can compare this Fourth Amendment example to a claim under ordinary private law. So if an ordinary citizen uses force against somebody else, then the victim might sue for battery. That's a common law tort, and it permits the victim to collect money damages from the injurer if they satisfy all of the elements of the claim. And so a battery turns out to have many of the same kinds of rules for determining whether or not the person is liable as the Fourth Amendment claim. The judge has to assess whether physical force was applied, whether the use of force was intentional, whether the injurer was acting reasonably in self-defense, and so on. So the Fourth Amendment is just one example, but that's what I mean when I say that constitutional private law is a kind of private law, because it has the same basic structure as private law, including something like battery. So why is it still constitutional law? Well, it's still constitutional law because it imposes obligations on officials because of their position as government officials, and it's ordinarily thought to be imposed because of the specific language in specific constitutional provisions. And so that's why I'm using the example of the Fourth Amendment in the Bill of Rights, which prohibits unreasonable searches and seizures. But other constitutional provisions sometimes impose duties too. The Takings Clause in the Fifth Amendment, the Free Speech and Free Exercise Clauses of the First Amendment, and the Due Process Clause and the Equal Protection Clause of the 14th Amendment. What I call constitutional public law has a different structure and a different function. So the rest of constitutional law doesn't impose relational duties like private law or like constitutional private law or like private law more generally. While these constitutional private law requires remediates wrongful conduct of officials, constitutional public law determines the validity of alterations to legal rules. And because legislation and judicial judgments are the primary mechanisms by which the governments or its agents alter legal rights of those subject to its jurisdiction, constitutional public law usually concerns itself with the validity of legislation or the validity of judicial judgments. So again, here are some examples. If Congress enacts a statute that's for some reason not authorized by its powers to regulate commerce under Article 1, or if it enacts a statute that's contrary to the Second Amendment or the First Amendment, then the statute is just invalid. It's null, it's void, it's just not law at all. The legislatures haven't done anything wrong, at least not in the sense that they could be sued for damages like our police officer under the Fourth Amendment. But the legislation is unconstitutional in the sense that it isn't supposed to have any legal effect. Similarly, if a judge enters a criminal conviction without sufficient evidence, or if a prosecutor excludes members of a particular race from the jury, then the criminal conviction can't stand and the criminal defendant walks free. Again, the judge hasn't done anything wrong that means you could sue them for damages, but the judgment of conviction has to be set aside, it's invalid, it's as if it never happened, it's ineffective to change the person's legal status. So the difference between these private law rules and the public law rules affects how we should think about adjudication of constitutional law more generally. So constitutional private law is about a victim seeking redress from an official for wrongdoing to that particular victim. The point of adjudication is to redress a constitutional injury. But adjudication of constitutional public law doesn't work like that. A litigant gets into court to challenge a gun regulation or to challenge some congressional statute because the government is threatening to put the person in prison or fine the person or deny the person some other legal entitlement. So the legal entitlement that gets you into court isn't the constitutional injury, and the redress that you want isn't for the constitutional wrong, but instead the point of the litigation, the point of adjudication there is to protect the other legal interest. And the constitutional rule is entering the picture in the constitutional public law adjudication because it says how and when the government can alter the underlying legal interest that you're using to justify getting into court in the first place. So again, a couple concrete examples will clarify what I mean by this. So imagine a plaintiff is seeking damages after an officer arrests her without a warrant. She's arguing that she's the victim of action by a police officer that breaches his obligation not to arrest her without a warrant. Because he broke that obligation, he has to pay damages. And the plaintiff there is invoking constitutional private law. On the other hand, imagine a defendant claiming that she can't be convicted of a crime for burning an American flag because the First Amendment prohibits a statute criminalizing that kind of expressive conduct. Our hypothetical flag burner is arguing that the law used to justify her conviction is invalid, And because that law is invalid, she can't be convicted, she can't be deprived of that non-constitutional liberty interest, and she's invoking a rule of constitutional private law. Constitutional public law. So what I'll suggest is that emphasizing this distinction tells us something about private law, and it tells us something about public law. So for private law, if I'm right that it's really kind of like ordinary private law that's been tweaked to apply to government officials, then maybe it's better to address that problem through private law than through constitutional law. And so for most of American history, there was no such thing as constitutional private law or constitutional torts or the Fourth Amendment claim for damages that I just mentioned. You could sue officials if they wronged you, but you would sue them under the common law. And so if constitutional private law and ordinary private law aren't that different in kind, then maybe a better way to address official misconduct is to rely on ordinary private law. And there are lots of advantages to thinking about the problem of official wrongdoing in this way. Private law is developed in the first instance by states and state courts rather than by federal judges. It's more open to normative or moral arguments about the kinds of obligations that people have to one another. And it's not tied to the methodologies and disputes about constitutional interpretation, which are, by and large, about interpreting relatively open-ended constitutional text. What about the rest of constitutional public law? Well, if most constitutional rules determine whether changes to legal rights are valid, then allowing constitutional litigation about those rules, if and only if there's some change to pre-existing legal rights, seems either over-inclusive or under-inclusive. It might seem over-inclusive where the plaintiff's legal entitlement permits her to insist upon adjudication of some really important political question. So think here of challenges to the constitutionality of the Consumer Financial Protection Bureau because of the way it was funded and because of the way the director could not be fired by the president. Those challenges were brought by regulated parties, but does it make sense to allow regulated parties to demand an answer on the constitutionality of a major government entity that Congress designed and the executive branch is seeking to use to make the world a better place? So that line of argument would suggest greater restrictions and limitations on adjudication of constitutional issues and leaving some of these issues to be dealt with by the political branches. Or you could take a different tack and you could say, well, sometimes it might be better to get a final word on the question of the constitutionality of an agency earlier. Like, why wait for an injured party to force the issue in the context of a fight about some other legal entitlement? If it is better for courts to answer questions about the constitutionality of the Consumer Financial Protection Bureau, then why wait until the regulated party is threatened with an injury? Why not settle the matter sooner? So that's my thesis, and those are what I take to be the stakes. And so from here, I'll spend a little bit more time elaborating on the structure and content of constitutional private law. Then I'll say more about constitutional public law, and then I'll come back again and conclude by elaborating on some of those implications that I just mentioned. Okay, so as I said, by constitutional private law, I mean relational obligations imposed on government officials by the Constitution, that if they're breached, they require damages as redress to undo the wrong. It's seemingly unique in that the Constitution is thought to be imposing the obligation, but it turns out that it's not just the structure of constitutional private law, but even its substantive content that has very, very close analogies in the ordinary, boring private law. So before talking about the structural analogy, let me start with some of the basics of ordinary private law. So if you go to court to sue another private citizen for a tort or a breach of contract, you'll have to prove certain elements of the claims to get money damages of any kind. So take as an example the tort of negligence, which is like the thing you spend half of your 1L torts class with in law school. And it covers pretty much everything from car accidents to medical malpractice to exposures to toxic substances. And so a plaintiff has to prove that the defendant has a duty, that the defendant breached the duty, that the breach of the duty caused harm, and that the harm is quantifiable in some way to seek out money damages. So to take the car accident example, a plaintiff that's been injured in an accident will claim that the other driver has a duty to drive carefully, that the driver breached that duty by texting and driving, and that the plaintiff was injured when he hit the curb and crashed into the plaintiff's car. If you want to sue for a breach of contract, it's more or less the same test, but the duty is created by agreement of the parties rather than background rules of law that impose obligations on strangers. So the plaintiff in a breach of contract case has to show that a contract existed, that the contract was breached, and that the breach caused the plaintiff damages of some kind. So to take a famous contracts or property example, suppose that a mining company pays a landowner for the right to strip mine coal from the property, and the mining company also agrees to restore the land to its prior pristine state after it's done stripping all the coal away. If the mining company takes the coal and then doesn't restore the property, then the landowner can sue for breach of contract and get damages that would make him as well off as he would have been if the company had performed the contract. So obviously, it's way more complicated than that. One else spend half of their first semester learning about torts and contracts, but those are the basics of those two kinds of claims. Constitutional private law has the same basic structure. A plaintiff has to show that the official has a duty, that the official breached the duty, and then that the breach caused the harm. So first, the duty has to run from the official to a specific person, not just to the public in general. So the normal rule in tort law is that a person has a duty of care to foreseeable victims of the person's misconduct. And so if someone is texting and driving and he hits the curb and he gets out to change the tire and somebody driving by is looking away and runs into somebody else, then a court might say that the victim wasn't foreseeable from the texting and driving and that might preclude liability. So this is imposing limits on the kinds of duties that individuals have to one another. The same is true in constitutional private law. In a Supreme Court case called Martinez versus California, state officials paroled a convicted criminal who later killed a teenager. The victim's family sued the officials, presumably because the killer didn't have very many assets, but they sued the officials and argued that the parole officials were responsible for the death because this killer should have stayed in jail and he wouldn't have committed the murder if he had. But the Supreme Court said that the officials were too remote because the officials did not know that the killer would take those actions and did not know that the victim was in any respect in special danger of this person's crime. So the point there was that the parole officers couldn't be sued for damages because they didn't have a duty to an unforeseeable victim of a third party's crime. A related point is that tort law normally doesn't impose affirmative duties to protect others. Sometimes that's called a distinction between misfeasance and nonfeasance, or between wrongful conduct and wrongful inaction. And it turns out that constitutional private law also incorporates the same basic distinction that tort law would incorporate. The famous case there is called DeShaney versus Winnebago County. And in that case, the social services failed to protect a child from severe physical abuse by the child's father. And the Supreme Court held that there was no constitutional duty to protect the child from the third-party father, even though officials had conducted welfare checks because they were concerned about the child. But the court noted that there are sometimes duties to protect people in state custody, like in prisons or in mental health institutions. And so the rules of the rules are that there's no general duty to protect, but an official's conduct might create a special relationship to the victim that requires some kinds of affirmative acts. And those rules are basically mirroring the set of legally enforceable duties in private law, where the normal rule is that there's no affirmative duty to protect, but certain special relationships, like between schools or teachers and their students, might lead to special responsibility. So constitutional private law insists that that the official has to be the one that breached the duty. And the technical way to say that is that constitutional private law precludes vicarious liability for governments and supervisors. Vicarious liability is when one entity is liable for the acts of another, and the most important example of this is respondeat superior. It's a rule that an employer is liable for the torts of the employee. And so if our negligent driver who's texting and driving is delivering pizza for a local restaurant, the local restaurant might be liable for the driver's negligence. That's the rule of respondeat superior. But respondeat superior doesn't apply in constitutional private law. So if a police officer violates the Fourth Amendment, the city or the state is not going to be liable just because it employs that officer. Supervisors of the officer aren't usually on the hook unless they're personally responsible for the failure to train or the failure to supervise adequately. So the supervisor has to have taken some action thought to be wrongful with respect to the supervision of subordinates. The point here is that constitutional private law imposes liability on the defendant only if the official is the one that actually committed the wrong. Now, that point is a little bit awkward for my argument about the analogy to private law, because in tort law, vicarious liability and respondeat superior is totally standard. So a long response to that would take us really deep into a debate about tort theory and the competing rationales for vicarious liability and also for tort law generally. But a very short answer is that here constitutional private law is revealing its commitment not just to the structure of private law, but to a particular vision of the point of tort law, one that's not just about ensuring that businesses internalize all of the costs of their actions, but also one that's but a focus on correcting wrongs by the particular parties who have committed them. That leads me directly to the next point about another structural feature of constitutional private law, which is if the official breaches whatever duty he or she has, then what? And the conventional answer is that he has to pay damages to the victim. Damages being a money payment that tries to put the victim in the position that she would have been if the accident had not occurred. So that requirement reveals constitutional private law's commitment to corrective justice, to correcting the wrong done by the official or restoring the victim as well as possible to the position that she would have been but for the wrong. And so let me draw attention to a few discrete rules that I think reveal that structure and the nature of redress here. So first, a constitutional private law claim for damages is brought against the official in what's called the official's personal capacity. And that's distinguished from a suit brought in the official capacity. And so formally, a personal capacity suit means the judgment can be collected from the official's assets. The official is the one who has to pay the judgment, and if the official doesn't, the way to collect it would be to garnish that person's wages, or put a lien on his assets, or have the sheriff seize the property and sell it off, or whatever other mechanisms you have under state law to try to acquire damages when somebody's not paying out a judgment. Now, in practice, governments usually do chip in to cover judgments for officials who've been found liable for wrongdoing. Sometimes states or localities promise to do it by law, or they agree to do it by contract. But the fact that the claim is brought against the officer in his personal capacity remains important. Doctrinally, the fact that the claim is brought against the official in his personal capacity is the whole reason that the claim isn't barred by sovereign immunity, which is the background rule that you're not allowed to sue a government to request money damages. And so constitutional private law isn't a suit against the government because it's a suit against the official. So the personal capacity suit is a necessary feature that makes litigation against the official possible in the first place. And the government is always retaining the power to refuse to indemnify its employees. So the personal capacity point is actually quite revealing about the structure of constitutional private law, because it's insisting that the only person that you can sue here is the official himself. And that's the person who's responsible to make good the wrong done. Second, how much is the officer supposed to pay? Again, constitutional private law is borrowing from the rules of ordinary private law. And the ordinary rule is that the official owes compensation for the injury caused by the defendant's breach of the duty. So the ordinary damages judgment is designed to restore the plaintiff to the position that she would have been, but for the wrongdoing. And the money damages are tied to the breach of that underlying duty. Now, victims are also sometimes allowed to collect punitive damages, just like they are in private law sometimes, if the official acts with malice or with conscious indifference to the rights of the victim. And that mental state requirement is again confirming that constitutional private law is committed to the view that the official has the obligations to the victim, and sometimes violations of the duty might be so egregious and so objectionable that the official has to be punished at the request of the plaintiff. The Supreme Court has explained, to take a concrete example, that punitive damages require, quote, a discretionary moral judgment, that compensation will not suffice, and that punitive damages are, quote, justified by the moral culpability of evil intent. And of course, the officials are the ones who have the intents, not the state as an abstract entity or the government as an abstract entity. So the remedies available for constitutional private law, from the imposition of damages on the official in her personal capacity to the requirement that the official compensate the victim to restore to the position that she would have been, to the rule that the imposition of punitive damages is for the evil intent of the officer, they all point to the same underlying theoretical structure of constitutional private law, which is that constitutional private law assumes a relational obligation, the breach of which is requiring correction, redress, restoration. It's a certain view of the requirements of justice between individual persons. So I want to pause there before turning to the content of some of these regimes, get more specific about what constitutional private law claims actually look like. But the aim so far has been to identify a pocket of constitutional law that has the structure of private law. It has that structure because it's imposing obligations on the officers in particular rather than the governments in general. The obligations are relational in that they're running from particular persons to particular persons rather than, again, just to the public in general. And the breach triggers a certain kind of liability, which is the requirement that the officer pay money damages, provide redress, restore the plaintiffs to the original position to correct the wrong done. And that's what I mean when I say that this form of constitutional law has the structure of private law. So what do these claims actually look like, and do they end up looking at all like other areas of specific kinds of private law claims? And the answer is yes. I'll give a handful of examples to show that the rules of constitutional private law are supposed to be constitutional rules. They're supposed to derive from the Fourth Amendment or the First Amendment or the Eighth Amendment. But it turns out that they're all really deeply related to private law analogs. They look very similar in their elements and in their elements to the kinds of claims that you can bring under the ordinary private law. So there are variations here and there to account for the unique problems of the official's status as a government employee, but by and large, the kinds of rules are quite similar. What that should suggest is that even though the constitutional aspect of what that should suggest is that the constitutional aspect of constitutional private law might not be terribly important for developing and implementing and thinking about what's going on in constitutional private law claims. So start with claims about excessive use of force. One of the first torts taught in most first-year torts classes, including mine, is the tort of battery. I mentioned it a little bit ago. And that tort protects against intentional physical contact with a plaintiff's body. And so I mentioned elements a bit ago, and the usual elements for battery are whether there was intentional, harmful, or offensive contact with the person of another. So intentional, harmful, or offensive contact with the person of another. You'll spend like 2 weeks of that in your first week in law school, and people get really bored with it by the end, but it's important. Anyway, there are similar rules that apply to the tort of false imprisonment, which is another intentional tort that protects against unlawful confinement of a person. But for both of these torts, there are defenses, and batteries and false imprisonment are ordinarily privileged if the person is defending herself, defending her property, or defending others, and if the force used is reasonable. And another defense is that even private persons have some authority to make arrests as long as the force or the confinement is reasonable, and if they have a good reason, like they witness some criminal activity. So the constitutional private law is recognizing variations on battery and false imprisonment under various constitutional provisions, including the Fourth Amendment and the Eighth Amendment and the 14th Amendment. So the Fourth Amendment protects the right to be free from, quote, unreasonable searches and seizures. It basically governs the activity of police officers. And courts have interpreted it to reproduce a constitutionalized version of battery and false imprisonment. So the clause is supposed to prevent excessive force of police officers, is just one example. And here, as courts have implemented what the tort is supposed to look like, they say that a seizure, the language of the Fourth Amendment, a seizure requires physical contact, and they say a mere touch is enough to count as a seizure. And that ends up being the same rule that's available for battery claims. The contact has to be intentional rather than accidental. Again, that's exactly the same rule that applies in torts of battery. And whether the seizure is unreasonable turns on a proportionality test about whether the force applied by the officer was excessive compared to the interest in making an arrest for the particular crime and compared to the risk of harm to the safety of the officers or the third parties. And again, that's exactly the structure of the defense for use of force for a battery, which is whether or not the force was reasonably necessary to protect private property or the person or some other third party. So although the test in constitutional private law is constructed from the language of the Fourth Amendment, it's really the same basic inquiry as it is for battery, whether the force is reasonably necessary for self-defense or the defense of others or necessary to make the arrest. Similar restrictions follow through the criminal process and provide protections for pretrial detainees because no one can be punished without an adjudication of guilt. And so the textual hook for excessive force claims for pretrial detainees is not the Fourth Amendment, but it's the 14th Amendment and the Due Process Clause, which says that persons can't be deprived of life, liberty, or property without due process of law. And that rule ends up becoming implemented as a constitutional private law rule about the reasonable or proportionate use of force for detentions. So the court has said that the use of force has to be reasonably, quote, calculated to effectuate detention and to protect the safety of officers and other persons. And just as with the Fourth Amendment and just as with battery or false imprisonment, the due process restrictions just require the reasonable use of force based on the context-specific imperatives of the actions of the official. And here it's about detention rather than arrest, but the same basic inquiry applies under different constitutional texts. So what ends up happening there is that the rules look basically the same, even though formally speaking, the court's supposed to be developing these rules based on totally different textual provisions of the Constitution, which suggests to me that what's doing the work is a theory about the requirements of officers rather than a theory about constitutional interpretation more generally. The Eighth Amendment also picks up on this excessive force line where and applies to the constitutional protections for prisoners, for people who've actually been convicted. And the Eighth Amendment prohibits, quote, cruel and unusual punishments, and the courts have said that punishments refer to criminal sanctions. Traditionally, the amendment just constrained legislation authorizing certain punishments or judicial sentences imposed by such judgments, but now courts apply the prohibition to the conduct of guards within prisons. And so here there's a bit of a leap from the objective rules of the Fourth Amendment and the rules for pretrial detainees, and there's a difference, and it's that with the Eighth Amendment, the court uses a subjective standard rather than an objective one to determine whether or not the use of force has been excessive. So instead of finding force to be punishment if it's excessive compared to some baseline of reasonable necessity, the court has said that the force just has to be, quote, in good faith effort to maintain or restore discipline rather than, quote, maliciously and sadistically to cause harm. So I want to highlight this difference for a moment between this test of objective reasonableness that applies in battery and false imprisonment and under the Fourth Amendment and under the 14th Amendment, and then on the other hand, a test of subjective bad faith or malice. Within constitutional private law, the official reason why the Eighth Amendment is supposed to require this higher standard about the officer's actual mental state is supposed to be the text of the Eighth Amendment. The court says it bans cruel punishments and says that cruelty is thought to require some kind of subjective bad faith rather than just excessive uses of force. But it's hard really to see how the text is doing that work because the amendment prohibited punishments enacted by legislatures regardless of their intent. And so if constitutional private law is really about the obligations of officials to other persons, then shouldn't the norms be developed based on something else? Maybe not the text, but based on whatever theories of obligation justify private law? I'll come back to that suggestion a little bit later near the end. I want to move from the long discussion of excessive force under the Fourth Amendment and the Eighth Amendment or the 14th Amendment, which I just took to show that the rules end up looking very similar to private law, even though in theory these are supposed to be developing very different textual provisions of the Constitution, which suggest that something else is doing the work of determining what the element should look like, and it probably is the exact same kinds of considerations that courts consider when doing private law, rather than the considerations they're supposed to look to when doing constitutional interpretation. And I want to briefly just mention a few more constitutional private law claims that aren't exactly like these excessive force tort cases. So first, Constitutional private law protects against officials' interference with real and personal property in a way that basically mimics the rules for trespass and nuisance. And those are the traditional torts that protect against physical invasion of one's property or with interference to the use and enjoyment of one's property. The property part of constitutional private law is housed under the Takings Clause, which says that the government has to pay just compensation if it takes private property for public use. And it's also housed, again, under the Fourth Amendment, which is protecting it against seizures of personal properties. And so if a government official seizes property without good reason and without judicial process, you might have a Fourth Amendment claim or a takings claim that ends up mirroring these property claims under the private law. What's unusual about stretching the Fourth Amendment to apply to the property claims is that it looks like the Fourth Amendment's becoming a kind of all-purpose constitutional text that justifies lots of different claims that would be treated differently under the private law, even though the text doesn't seem to have all of these distinctions within it. Second, constitutional private law also protects against officials' interference with privacy interests, again, through the Fourth Amendment. So the court has held that a strip search might be an unreasonable search because it interferes with expectations of privacy, because it's embarrassing or humiliating and frightening. And a lot of these cases can happen in schools, but they apply also more generally. But if the Fourth Amendment wasn't available, then private law would have had another claim that's available to deal with problems like strip searches. They're called the privacy torts, and there's a tort called intrusion on seclusion that basically deals with exactly these problems, which is people looking at things that are private in various ways. Third, constitutional private law also constrains rules prohibiting government officials from acting for impermissible reasons. So as examples, government officials who act as employers can't discriminate against employees on the basis of sex, race, religion, any protected characteristics without violating the First Amendment or the Equal Protection Clause of the 14th Amendment. Prosecutors and law enforcement can't arrest or prosecute someone to retaliate against them for their speech or because of their religious views. And these kinds of rules all limit the reasons under which officials might act. So these claims all provide a reason that I reference contract law at all, that I even talked about contract law rather than just torts, because some of these rules are governing employment relationships between the parties, and employment relationships are a matter of contract and usually dealt with as contract and agreement. And so lots of constitutional laws operating not just to impose tort-like obligations on police officers and prison guards, but also to impose mandatory contract provisions on the agreements between employers and employees. I'm going to move on to constitutional public law in a moment, but to sum up now the discussion of constitutional private law so far, it has the structure of private law because it imposes relational duties on government officials that, if they're breached, require a certain kind of redress or restoration, usually in the form of money damages to compensate the plaintiff or maybe even punish the defendant. The content of constitutional private law likewise reflects the content of ordinary private law, as with the analogies between battery and false imprisonment and the Fourth Amendment. But there are obviously modifications across ordinary private law and constitutional private law to reflect that constitutional private law is supposed to be justified as a form of constitutional law. So the claim ultimately is supposed to follow from some effort to interpret constitutional text through the language of the Fourth or the 14th Amendment or the 8th Amendment or the First Amendment. What I called at the outset constitutional public law doesn't work like that at all. And indeed, what I call constitutional public law is probably what most everybody thinks of when they think about constitutional law at all. And the differences are not just about the kind of legal rule that constitutional public law is imposing, but also in the way that constitutional public law ends up getting adjudicated in court. So first, constitutional public law is enforced through a kind of legal rule that operates very differently from the relational obligations discussed in private law and in constitutional private law. What constitutional public law does is determines how you get to make and alter legal rules. So how and when legislatures can change legal entitlements, and how judicial judgments can make a person liable to pay damages or liable to be in prison for their wrongdoing. So think first about constitutional rules that constrain Congress or state legislatures. Legislatures might have some responsibility to enact wise laws, but the responsibility is not owed to any person in particular, at least not in the way that the private law with redress, at least not in the sense that you could sue the legislature for enacting a bad law. In fact, while the relational duties of private law preclude certain conduct in the world that's interfering with legal entitlement, legislation operates on legal entitlements in the world of legal rules. So constitutional rules governing legislation constrain the alteration of those legal entitlements, and they determine whether the purported exercise of lawmaking power is effective to change the law. And so lawmaking might be ineffective because Congress has failed to satisfy one of the procedural restrictions on the exercise of its power, because it's exceeded its authority, or because the statute is just contrary to the constitutional rights of the citizens. So again, let me give some examples of what I mean by constitutional public law. So Congress gets to enact legislation. Whether they do is another matter entirely. But if it wants to enact legislation, it has to do so through a process called bicameralism and presentment, meaning, of course, that both of the chambers have to concur in the same text, and then the president has to sign it. So if Congress purports to make law some other way, like the House enacts a statute, but the Senate doesn't vote on it, then the law is just void. It's ineffective, it's invalid, it's not law. And so if a federal prosecutor tried to bring a prosecution against you under a criminal statute that failed to satisfy the requirements of bicameralism and presentment, you would just say, that's not a law, you can't put me in jail for that. The same basic rule actually applies to legislation that exceeds Congress's enumerated powers and those that violate provisions of the Bill of Rights. So Congress has various powers in Article 1 of the Constitution. One of them is the Commerce Clause. They can regulate commerce. But if Congress enacts a statute purporting to regulate commerce under the Commerce Clause, but instead it compels non-economic activity, then again, the statute is just void. The courts will treat it as if it was never enacted. And if Congress passes a statute stating that the punishment for a particular crime is drawing and quartering or something terrible like that, then the statute is just invalid or void. So contrary to the Eighth Amendment's ban on cruel and unusual punishments. So note the difference there in how even the same provision of the Constitution is operating to produce two discrete and different kinds of legal rules. The Eighth Amendment in the world of constitutional private law is operating as a rule that constrains the activities of prison officials and the obligations that they have to prisoners. And if they breach that obligation, they owe money damages. But the Eighth Amendment in the world of constitutional public law is also limiting what punishments Congress might prescribe, but violating the norm doesn't mean that Congress has to pay damages. It just means that the statute is ineffective, it's invalid, it's void. It just fails to change the legal status of citizens subject to the jurisdiction of Congress. The same is basically true with respect to judicial judgments. So the court has said that the Due Process Clause requires evidence showing that a crime was committed beyond a reasonable doubt if they're going to be convicted for a crime. If the evidence at trial falls short of that, then the judgment is just null and void. The criminal punishment imposed by the judge on the basis of that evidence has to be set aside. And so for both legislation and for judicial decisions, the way that constitutional rules operate is to determine the validity or not of efforts to alter the legal status of persons subject to the order. That affects the way you think about constitutional adjudication. So again, at least in law schools, we think of constitutional law as just a series of judicial decisions implementing the Constitution. The focus is on courts, and in particular the Supreme Court. And so note here how different the adjudication of constitutional public law is compared to the adjudication of constitutional private law. So if the claim is that a statute is void or invalid, you don't sue the legislature for a determination that it's invalid and ask the legislature to pay you money damages. You can't sue Congress for enacting a statute that bans flag burning, even if you want to burn a flag. You have to get into court some other way with some other injury. That might be that the government decides to bring a criminal enforcement action against you, and then you can raise the invalidity of the statute as a defense in the criminal proceeding. Or you might sue another private citizen for damages, maybe under a statutory cause of action created by Congress or under the common law. And the defendant might assert some constitutional bar as a defense in that civil proceeding too. A similar kind of argument applies to judges. If the claim is that a judicial decision somehow violated your legal rights, you don't get to sue the judge for damages. You can appeal the decision or maybe seek well, I was going to say seek a writ of mandamus, but I don't want to go into what a writ of mandamus is. So, so you can appeal the decision, but what happens here is it channels the claim either before, you have to bring your dispute about the constitutionality of the judge's decision either before that judge in particular or before someone else in the appellate proceeding. And the ultimate question is just whether or not that initial judgment lawfully changed your legal status or the other party's legal status. And so there are all sorts of variations and complexities on how this works, but the point I want to make is that when the invalidity of legislation or a judgment is asserted in adjudication, the reason for the adjudication and the interests protected by adjudication are not the same as the underlying constitutional rule that's being asserted in the litigation. So take again the example of the criminal prosecution. The underlying legal interest that justifies the invocation of a constitutional public law rule is like your right to life or liberty, not to be put in jail or deprived of your life without due process of law. And so what's protected is a pre-constitutional or non-constitutional set of interests, and it's protected by a constitutional rule against certain kinds of changes or alterations. The same is basically true in the context of a civil suit. So, you know the famous decision in New York Times versus Sullivan? Yeah, okay, all right. Where the government official sued the Times under the common law of defamation, and the Times argues that the First Amendment precluded the imposition of liability. So the reason for the adjudication was the Times' breach of an obligation under the private law not to defame the government official. And the legal interest protected by the reason for adjudication is like money. That's what was at stake. It was money. The plaintiff wanted money damages for compensation. But the legal interest protected by the constitutional rule, so the legal entitlement is entitlement not to be forced to pay damages under an unconstitutional statute, and that's only incidentally related to the interest protected by constitutional law, which is something like, I don't know, preserving the marketplace of ideas in the context of the First Amendment. So contrast that back with constitutional private law, which unites the constitutional norm and the legally cognizable harm. So go back again to my Fourth Amendment example. Whenever a person has been unreasonably searched and seized, the Fourth Amendment norm against unreasonable searches or seizures justifies a suit for redress. Likewise, the constitutional norm prohibiting discrimination on the basis of race or sex or religion might justify a suit for redress simply because the person has been treated differently. So to be sure, showing harm or damages may depend on articulating non-constitutional interests like the loss of employment or injury or you spent money going to the doctor or something. But the reason for recognizing those losses as cognizable losses flows from the constitutional wrong directly. So let me offer some reasons why I think the distinction matters for the way we would think about law, and I'll say something about the way we would think about private law, something the way we think about public law, and then also something about the way we think about how law should be studied in law schools or in university settings. So isolating the category of constitutional private law offers better ways to think about constitutional private law and ordinary private law. As to constitutional private law, if the development of constitutional private law ends up looking quite a bit like ordinary private law, it might be because the justifications for the doctrines are rooted more in the reasons for private law than the reasons for constitutional law. In other words, the reason for constitutional private law might really be about the obligations that people have to one another, obligations that the private law picks up on and enforces, but with the twist that the people who have obligations here happen to also be in positions of authority and power over citizens or subjects of the regime. If so, treating constitutional private law as an aspect of constitutional law might sort of miss the point. It might be odd to insist that categories of wrongs by government officials are exhausted by the precise language of the constitutional text. You might ask, why cram the claims into the language of unreasonable searches and seizures when it's really just about the unreasonable use of force, just the same as it is in battery? Why attempt to derive the mental state for misconduct by prison officials from the cryptic words, cruel and unusual punishment, when really the point of the claim is to protect prisoners from excessive and malicious uses of force, which is something that the private law deals with all the time? Why not just engage in the same kind of reasoning that judges engage in for ordinary private law, where the point is to develop the doctrine to be reflective of what people owe to one another? It might be better to tweak the rules of battery and false imprisonment or malicious prosecution or a tort called misfeasance in public office, which is available not in the United States but in some Commonwealth countries. And in fact, before constitutional private law emerged in basically the 1960s, claims against officials were handled under the private law, under the ordinary rules of the common law. As to ordinary private law, the analogy between private law and constitutional private law might run the other way too. So right now, in most states, ordinary rules of private law still apply to state and local officials, with lots of variations and lots of exceptions. So you can still usually bring claims of battery or false imprisonment against state officials under state law, though plaintiffs often prefer to bring constitutional private law claims because they can get attorney's fees in federal court. So constitutional private law has kind of displaced these state common law claims as the primary source for defining the obligations of officials to others. But the analogy to constitutional private law and the point that the constitutional aspect seems overemphasized suggests that another way to develop the common law that applies to officers is just to develop the rules of private law. The point is not that ordinary and constitutional private law should converge, but the analogy suggests that state law offers a forum for experimentation beyond the limits of constitutional law in federal courts. The analogy to constitutional private law thus offers the possibility that state law might articulate repudiated or novel theories of constitutional law as a part of the law of the state. And that possibility could relocate the generation of norms constraining public officials away from the federal courts and from the interpretation of the Constitution to state courts, to state legislatures, and ordinary state non-constitutional law. Distinguishing constitutional private and public law also highlights some of the bizarre features of adjudicating constitutional public law. So the basic problem, again, is that adjudication of constitutional public law occurs only where there's some prior legal interest protected. So there's a criminal proceeding brought under a statute that appears to exceed Congress's power, or a statute that criminalizes the possession of a handgun by a law-abiding citizen. The reason for the adjudication is the protection of the background entitlement to not be taken to jail without due process. But the reason for the constitutional provision at issue is something like preserving state autonomy over local regulation or ensuring that citizens arm themselves for purposes of self-defense. And so that mismatch produces two potential kinds of problems. The first might be that you just have too little litigation or at the wrong time. If you have to wait until someone has been injured to litigate the constitutional question, then adjudication might not fully enforce whatever policy is instantiated in the relevant constitutional provision. If judicial review of federal or state legislation is desirable, why not develop processes to engage in immediate review of the legislation, a kind of council of revision recreated to permit judicial review of legislation before any harm is inflicted or threatened? The second potential problem could cut entirely in the other direction, which is maybe adjudication of constitutional claims is too frequent. Maybe it's too easy, because there's usually some underlying legal entitlement that someone can invoke to justify review of the constitutionality of legislation. The response there might be to recognize that not every constitutional claim has to be available in every litigation in which it might be invoked. And the doctrinal response might be to defer more freely to legislative and executive determinations, to impose stricter requirements on when people can demand adjudication of constitutional issues, or conclude that many more questions are political questions beyond the capacity of judges. The point there would be that adjudication of constitutional public law is not really about the entitlements of the plaintiff or the defendant, but about the construction of a polity that follows certain sets of constitutionally important rules and norms. And adjudication about those rules has to be in service of the construction of that polity. So that brings me to my final points about the distinctive contributions of like studying constitutional law in a law school. If adjudication about constitutional public law is about designing an effective and institutionally balanced government, then the questions of constitutional law are really quite well addressed if not exclusively, but maybe primarily, in the domain of political theory and political science. Domains equipped to answer questions about ideal regime types, about systemic consequences of certain kinds of institutional designs, about the consequences of deploying judicial review in this or that context to construct a system of good governance. Legal scholars might have something to add, particularly in the problems of process and procedure, but the expertise for designing the adjudicative system is much more diffuse if we're just talking about designing a good constitutional system. But adjudication in constitutional private law is maybe different. There, the point of constitutional adjudication is restoring, correcting some rupture in the relationship between the parties. And figuring out how to do that might be distinctively a problem of law, because the law regularly, in the domains of contract and torts and so on, articulates legal rules to determine what counts as legally wrongful, when there's been a breach of a duty, and what the redress has to be. Now, that's also not to say that other disciplines have nothing to say, but there, the distinctive contributions of legal thinking might have to be brought to bear if the practice of correcting wrongdoings by officials is going to make sense at all. So thank you all very much for listening. I'm very much looking forward to the conversation.
Thank you very much, Professor West. All right, so the floor is now open for questions. Our tradition in the Madison program is to recognize students who have questions first. I'm wondering if any of our students here, I see some students from Constitutional Interpretation and Civil Liberties. Any of the students have questions? Yes, over here. Yeah, Ben Woodard.
Does the source of the cause of action play any role in this scheme? Like, a lot of the stuff you're talking about is through Section 1983, it's actual order of the cause of action, which is statutory. Some of it's through Bivens, which is a technical term made up. So, does the differing origins of the cause of action for these constitutional private law claims, like, does that affect your scheme at all?
No, I don't think so. I mean, it does suggest that maybe you shouldn't call it constitutional private law so much, because in the 1983 context, well, first, I'll say like 2 beats on Section 1983 and Bivens. The claims we're talking about, most of the time, they're going to be brought against state officials and local officials, and there's a statute that authorizes those claims. It's called Section 1983, and it says something like any person that causes someone to be subjected to a deprivation of constitutional rights can bring a lawsuit.
If you act under color of law.
If you act under color of law, right, exactly. And you have to deprive someone of constitutional rights, right? So that's Section 1983, and then there's also Bivens, which is, to use a technical term, made up, maybe, I'll get back to that. And that's directly inferred from the Constitution. I mean, some people would say it is of constitutional origin, some would say it's inspired by the Constitution, but in both of these contexts, yes, there's something else that's kind of implementing the making it possible to bring the claims entirely. So you might say Section 1983 isn't really constitutional private law. It's statutory law created by Congress. But I don't think that quite works, because under the current way that we think about it, in order to assert a claim under Section 1983, you have to identify a violation of a constitutional right. So it will be very common for claimants bringing these cases and filing lawsuits just to write in their complaint something like, count 1, violation of the Fourth Amendment. And they won't even really reference Section 1983, because people really do think about them as the Fourth Amendment. I was going to use the reference to Bivens to suggest that some of what I say here gives maybe better grounding for Bivens, because one of the theories of Bivens that it's made up is that constitutional private law, as I'm calling it, is something totally new and invented in basically the 60s and the 70s. And if it's new and invented, and if constitutional interpretation is supposed to be basically continuous with the founding or with the 14th Amendment or with whenever the constitutional text was enacted, then it's very suspect, because it seems like judges are just, to use a technical term, making it up. But if you think that what's going on in constitutional private law is really basically producing a kind of general federal common law for officers, imposing obligations on officers in their capacity as officers, then you might think that these kinds of claims are basically continuous with the early common law claims that were brought against state officials. So I mentioned at some point that, like, at the time of the founding, you wouldn't bring a Fourth Amendment claim against the sheriff. You would bring a trespass claim or claim for, like, ejectment or replevin or other common law words that I don't remember and can't keep straight. You would bring one of those claims, and the idea would be they violated the ordinary private law. And so if constitutional private law is a little bit of a misnomer and it's really just a general federal common law of officials, well, then that looks like it's basically continuous with the common law of 1789 rather than a radical rupture that's, to use a technical term, totally made up.
For the adults in the room who noticed how brilliant Ben's question was, you might wonder, are all his students that brilliant? Yeah, they're all that brilliant. Yeah. Any other students want to show off their brilliance? Is that a question back there? Yeah, there you go.
Student, but I'm not a brilliant one.
We'll be the judge of that.
Do you think it's possible to isolate public and private dimensions for other fields of law? So it doesn't just have to be the 1L curriculum, but if you're suggesting that constitutional law, which is usually thought of as public, can be private, what about torts, which is traditionally private? Surely there's a public dimension.
Yeah, so that's a really good question. So I've started to think that trying to distinguish that could be helpful in figuring out, trying to draw the analogy between constitutional law and certain areas of private law would be helpful. And so here's what I mean by that. When I've been talking about private law, I'm actually referring to a very specific aspect of private law, which is the part of private law where you already have the duty, you already have the obligations, and somebody breaches it, and then somebody has to pay damages. And you can find that aspect of private law in tort law, in contract law, in property law, and so on. But there's also something else that happens in private law, and that is in fact much more important in areas that are not tort law, which is you can alter legal relations. Like if you enter into a contract with somebody else, you're altering your relationship with that person and creating a specific duty. If you put an easement in somebody else's property or you transfer title to a plot of land, those are mechanisms to actually alter the legal entitlements that other people have. There are lots of other examples too, like writing a will alters people's legal entitlements, et cetera, right? So one thing you could think is that actually that's like the public law component of private law. You could say that what constitutional public law is about when you can effectively, validly alter legal rules. And the analogy you want to draw is from those rules over to the parts of private law that are about the alteration of legal rules. I don't know what you would get by trying to draw that analogy, but I think it might be helpful and interesting, and that's a really good question.
So Garrett, on that understanding, would all the categories of rules that Herbert Hart would file under power conferring rules be public law rules?
I think so, and then that causes a problem for my whole schematic, because that would suggest that...
Yeah, I get it.
Yeah.
Other questions? Well, why don't we open the floor now, students, postdoctoral fellows, everybody. Who's got a question? Dimitri, yeah. Your future colleague at Yale.
Oh.
Dimitri will be joining the political science department.
Great.
Oh yeah, thanks so much. Really interesting talk. I suppose this is related a bit to the Bivens question, but so I guess the interesting case is, or these Fourth Amendment cases where you can sue for damages, and I guess you said, I mean, there's Eighth Amendment cases, but the lion's share of these, as I gather, are Fourth Amendment cases. And so what is the rule to distinguish, what sorts of constitutional violations allow you to sue for damages and what don't? So I mean, if the legislature passes a law that's unconstitutional, obviously that violates the First Amendment, you couldn't sue for damages. But if someone just violated, some government official just violated a First Amendment right, on what basis shouldn't you be allowed to sue for damages there that distinguishes it from Fourth Amendment cases?
Mm-hmm. Yeah. So how do I attack this? The answer is it's not. Courts aren't very good at distinguishing it. So there are lots of doctrines that prevent you from being able to sue particular kinds of officials that deals with most of the problems, right? So like you can't sue a legislature because there's a doctrine called absolute immunity for legislatures and absolute immunity for judges. You can't sue. Why you have those rules we could have a long discussion of, but like you can't invoke constitutional provisions to sue judges, acting in their judicial capacity, legislatures acting in their legislative capacity, or prosecutors if they are intimately connected with the judicial process in some respect. So that precludes like private law creep over into the world of public law. And I think a reason to have these doctrines that prevent private law creep into public law world is that there's something like it seems like it's kind of incompatible with the nature and structure of lawmaking and judicial decision-making, that if you had specific relational obligations to each individual person, like what would that even mean? I'll give you the example of judges. Like, imagine the judge had relational obligations to each of the parties, and he breached it by getting the decision wrong. So he breached an obligation by getting the decision wrong, and then you'd sue the judge for getting the decision wrong. But what if the second judge got the decision wrong? Would you sue that judge too for getting? So then you have like an infinite regress, whatever.
Who would ever agree to be a judge?
Who would ever agree to be a judge too? Right.
And part of the answer to Dimitri's question is the standing rules? Standing is going to prevent a certain amount of creep, for sure, right?
Standing will also prevent a certain amount of creep, but standing is basically imposing a kind of requirement that it basically be private law, because you have to articulate an injury that is closely associated with the kinds of injuries that you can articulate as a normal, boring private law injury. Like, I got hit by a car and then had to go to the doctor. I slipped on a banana peel. That's a classic tort case. I fell off a boat and drowned. Ooh, that was dark.
Other questions? Yes, floor's open. Yes, Mrs. Zinser.
All right, I'm starting a new category here. I'm neither a student nor brilliant. So my question is, you said that constitutional private law emerged in the 1960s. Why? And if they made it up, where were the legal scholars?
Okay, so the question why is actually really complicated and contested, and I'll give you like some theories, but I don't have a good answer for you. So a boring answer is there's a case in 1964, don't quote me on 1964, but basically 1964, maybe 63, called Monroe versus Pape, that has a very aggressive interpretation of the language of Section 1983 that some people think generated the possibility of bringing a lot of these claims. Another possibility is that separate from the development of constitutional private law, in boring constitutional world, the uninteresting part that most people think about, a thing called incorporation is happening, which is that the Bill of Rights originally only applied against the federal government, and it starts to be incorporated against the states as well. So what happens is you incorporate new constitutional provisions against the states, you have more opportunities to bring constitutional private law claims under Section 1983, which, by the way, in Monroe v. Pape, has just been interpreted quite broadly. A third possibility is the judges are just making it up. A fourth possibility is, and this is a more charitable version of the judges are making it up, is that from a lot of United States history, there was a less positivistic understanding of legal rules, and they had a thing called the general law that they thought was basically shared across jurisdictions, and judges maybe felt they had a little bit more ability to develop the common law ordinarily. But over the course of the 20th century, you no longer can like make it up in the same way, and you have to be able to point to a specific constitutional text. So maybe what happens in the second half of the 20th century is all of the litigants who want vindication and all of the judges who want to provide some kind of relief for something that might have otherwise been treated under the common law gets brought over into constitutional tort world or constitutional private law world, because there the plaintiffs can say, oh, I've been wronged, and it violates, here's a specific text of a particular amendment. So all the sort of like creative development goes from the common law over into the language of the Constitution itself. A last version, and maybe this is the best one, is at some point Congress enacted a statute that allowed attorney's fees to be recovered, which is not the normal rule under the private law. You can't normally get attorney's fees if you win. And so maybe they just they can now afford to hire a lawyer to bring the lawsuit, and so there were lots more of them.
Other questions? Yes, Michael Rosen.
You said that constitutional private law actions can only be brought by individuals or maybe very small groups. I was Professor Lessig's historical consultant in the anomalous elector cases, and we argued that electors had freedom. Of course, I always wondered what were the best arguments on the other side. The Attorney General of South Dakota, joined by 43 other states in the D.C., filed an amicus brief in support of the states against us. South Dakota does not have a statute purporting to bind electors. And I've always wondered, is there an argument to be made on behalf of a large segment of the body politic against the electors understood as government officials for violating an implied contract. And I'd just like to bounce that off you.
Yeah, I mean, it's interesting. It goes, I think, to the question of why, when it makes sense to have something that looks like private law and when you want to preclude the imposition of relational duties in some respect. So, I mean, here it's kind of like, how exactly is that going to work? You're going to sue the faithless elector for throwing the election, and you're going to collect money damages from the faithless elector on behalf of the entire body politic. So another way of thinking about it would be, if they get there in time, they can sue for what's called specific performance in contract, which is the remedy that's like an injunction that orders them to do something. So you sue and you say, you've already agreed to vote in this particular way, and you'll harm us if you don't, and so we're going to force you to do it with a judicial order. Yeah, I mean, I don't know that that would be I don't know how that would fit into the constitutional framework I was just articulating, but if I wanted to make sure a faithless elector voted the right way, I might be willing to try that theory.
Other questions? Yeah, right behind you there. There you go.
More of a situational question. In listening to you and talking about this, and you used a couple examples of the unlawful confinement. Current situation, say that Ms. Ozturk from Tufts University, a graduate student that was snatched up by ICE just yesterday by a group of men with no uniforms, did not show their badges, didn't have a warrant, whisked her away. Does she have any course of action, or her family would, for even suing individual officers through this?
So I don't know. So one problem would be, one difficulty would be the Bivens point, which is that I presume these were federal officers. And so it's very difficult to get a cause of action against federal officers because there isn't that Section 1983 statute, and the current courts are very skeptical about implying new causes of action under the Fourth Amendment. So probably she doesn't have a cause of action. Let's assume she does have a cause of action. You would want to run it under the Fourth Amendment. The question would be whether they seized without a warrant or without probable cause for whatever reason. I don't know what the facts show on that. And then the other question would be, was there excessive force? But the damages for that would be relatively limited because it would be only focused on the excessiveness of the arrest rather than the legality of the arrest itself. One thing you can bring under the Fourth Amendment currently under Section 1983 is a Fourth Amendment malicious prosecution claim. Is if you bring a prosecution without probable cause that causes the detention of a person. So that's a claim that could be available in a state case, but I think it's very unlikely that it would be inferred from the Constitution against federal officials because of the Bivens point we just talked about a little bit ago. On the other hand, courts are more willing to find implied causes of actions for prospective equitable relief, so to get an injunction to get like out of jail or something. But sometimes specific statutory schemes for detention or deportation like displace background remedies, so that might be going on there too. But I don't know, and I should not be taken. I've not thought about that at all until this second, so that's not legal advice. I'm not barred in New Jersey.
Other questions? Oh, yes, Madeline.
Thank you so much. But it just sounds like the advantage of constitutional private law might be that it increases the moral accountability or the sort of standard of care among public officials, which might be better for the victims in seeking retribution or justice. But would this create any difficulties for public officials in doing their jobs? Is there a reason why they're so separate now from the private law in order to sort of function?
Great question, and that's what like a lot of the fights about how to develop and implement constitutional private law talk about. You know, they're like mixed justification. Well, okay, let me step back and say what the justifications that people tend to give for why to have constitutional private law in the cases and why those cut in different directions in your example. So sometimes people talk about private law, constitutional private law, like I was talking about it, like it's about justice or corrective justice or restoring the relationship between the parties or something like that. And then other times they talk about it as a way to constrain and confine the activities of the government. And so on the first theory, it's about the past, and it's about making good a wrong done. And on the other theory, it's about the future, and it's about trying to make sure the government behaves itself in the future. A lot of times you'll think that those two justifications for the legal regime work together, and then there will be no real dispute about what the rule should look like. If you think that the rule's both going to make good the wrong done and also make the government behave itself in the future, then like, perfect rule, we love it, right? Sometimes I think people think that they come apart. Like maybe we're trying to make good the wrong done, but it's going to inappropriately chill the public official. One problem with trying to think about the doctrinal regime as doing both the backward-looking and the forward-looking thing is that it does cause challenges when you don't know what when you think there's a conflict in whether a particular rule would serve both ends. If it would serve one but not the other, which one do you choose? I'm inclined to focus on the sort of backwards-looking way of thinking about it, in part because the forward-looking version has so many difficult, contestable, empirical assumptions about the effect of making individuals pay money damages, like how much will they be chilled in their official capacity? Will they be indemnified by cities and states? Will they... would other mechanisms be more effective than paying money damages, and so on and so forth?
Other questions? Garrett, I lived 5 years of my life in England as a student and then a faculty member, and associated with a lot of legal academics and practicing lawyers. This was back when England was a free country. You couldn't be arrested for praying or posting tweets that other people found offensive. But there were two things about the American legal system that I noticed British lawyers and British folks generally just found perplexing. Really, couldn't understand why we do it. One was the contingent fee. They didn't get that. That seemed to be a very bad policy from their point of view. The second is the one I want to ask you about, and that is the exclusionary rule. And I bring it up for this reason. When I would try my best to defend the exclusionary rule, being a good American, I didn't know whether I believed in it, but I wanted to stand up for my country. So, this is the rule that says that unlawfully obtained evidence, evidence obtained in a criminal prosecution unlawfully by the police is not, except under certain circumstances with exceptions, admissible in the trial. So, I wanted to explain, this was our way of deterring police misconduct. And their response every single time was, wait a minute, you're excluding valid probative evidence when you could do like the sane and sensible thing, which is either punish the police for their unlawful act in obtaining the evidence, or subject them to civil liability. Now, is this a case where we have essentially imported into public law a private law matter? And when we go beyond the criminal to the imposition of civil liability, and we've basically taken it out of the domain of private law and vested it in the domain of public law.
So it's a great question. I think it actually dovetails really well with Madeline's question, which is, I think it depends a little bit on what you think the point of the exclusionary rule is. So a couple times in the talk, I would say, usually damages. And the reason I said usually damages is because I wanted to hedge. Because there's a theory of the exclusionary rule that's not the normal one, which is what the exclusionary rule is for is not just about deterrence, but is about making good the wrong done. The police officer got an unlawful advantage on the person by getting illegal evidence, and so we have to restore the person into the position that the criminal defendant would have been if the police officer had not done that. I think that's the best argument for the exclusionary rule.
I actually not heard that argument.
But it also goes back to the point of what do you think the exclusionary rule is doing? And maybe one thing it was doing is some people think maybe it's about justice, and then there's the question of deterrence. But if it's about deterrence, then you want to ask, wouldn't it be better to do civil liability, or wouldn't it be better to punish them? Or you would want to ask the empirical question, how do police officers actually respond to the exclusionary rule?
Exactly.
What would be more effective, making them pay money damages or letting the criminal defendant go? I mean, one argument, you probably came up with this while you were defending America overseas, is like,
Patriotic me.
the police officers don't really, they might not pay the damages judgment because the police department will be very happy to pay, you know, and a lot of times the damages will be quite small because you won't, you know, you go into somebody's car and you find they had an unlawful gun. What are actually the damages to the person from the police officer going into the car and finding the gun? It's $1, negligible. So it won't do very much deterrence. And so what you really want to do is you want to hit them where it hurts, because you know what cops don't like? They don't like when the bad guy goes free.
Right. And of course, the response of my English friends was, the whole public pays the price.
Yeah, right, of course.
Not police officers. Police officers really, you know, marginal here. It's
Right.
the whole public pays the price
Right.
of having this criminal back on the street because you guys let him go despite having probative evidence because the evidence was lawfully not obtained, or not lawfully obtained. Other questions before we conclude our deliberations for today? Yes, absolutely, back there.
So I'm not brilliant, I don't have a Princeton connection, other than being your neighbor, but I was a juror in Trenton for a gun possession case that was pretty quickly, it was a third-time charge. But my question more is about practices of the police department. And when there are, you know, post-George Floyd environment, where there are these very public cases where police, in some cases, are accused of very bad crimes. In some cases, they're found innocent. But what you don't know is that the police departments have to pay very high insurance fees to cover the liability.
Mm-hmm.
Is there any guidance for those types of systems, so those types of very difficult situations that can relate to some of your discussions, or like do you consult or give advice to, especially urban police departments, to address, because it's always going to happen, and it's a really very, very unpleasant situation.
Yeah, so I don't consult. Do you know whether these police departments pay a lot? No, I'm kidding. Their insurance premiums are high. So one thing that's really, so a background fact about this whole thing that is a little bit contrary to my general thesis is that most of the time the police officer doesn't pay. Most of the time, the police department will pay, they will indemnify. Many states have statutes that basically require it unless the police officer acts in really bad faith. And other times it's negotiated in the contract, and other times the officials just do it anyway. So most of the times it's insurance companies. Another thing that's unusual is, actually it turns out that many of these insurance companies write really detailed guidance to police departments explaining here are legitimate police department practices, here's when you should do a chokehold, here's when you should be able to tase somebody, and so on and so forth, because they're trying to reduce the availability of damages judgments, which is, on the one hand, it could be a good thing if you think that what should be happening here is we should have some kind of deterrence function, because that would mean, wow, making the police departments pay money damages made them get insurance, which made the insurance help them not do the bad thing anymore. Another thing is that it seems a little odd to have insurance companies be dictating how a particular location should be engaged in policing. So, yeah, I don't know. It's a hard problem.
Well, before I invite you to join me in thanking Professor West for his wonderful lecture and this great Q&A, let me urge you again to go to the Madison program website to see what events we have coming up. Also, monitor our Facebook and Twitter and Instagram accounts. Mrs. Parker, off the top of your head, do you know if we have anything coming up next week? Monday, Eric Kaufman with Greg Conti, Professor Greg Conti here at Princeton.
That's right, it's in a bowl in Robertson at 16.
Robertson Bowl 16? Yes, okay, very good. Well, please do join me in thanking Professor.
Thank you, everybody. Thank you.